Be ready for the dictation. 5, 4, 3, 2, 1. Start. Leave granted. This judgment visits a familiar conundrum in service jurisprudence. The constitutional values which undergird Articles 14 and 16 mandate that selection processes conducted by public authorities to make recruitments have to be fair, transparent, and accountable. All too often, human fallibility and foibles intrude into the selection processes. Selection involves intense competition, and there is no dearth of individuals who try and bend the rules to gain an unfair leap in the race. Irregularities in the process give rise to misgivings over whether the process has denied equal access to all persons. The sanctity of the selection process comes under a cloud. The detection of individual wrongdoing by candidates may result in action being taken to exclude those whose credentials or performance is tainted. But when the entire process is tainted, the authority in charge of conducting it may decide to cancel the selection as a whole. Judicial review is then invoked to challenge the decision to cancel the entire process. The guiding principles have evolved over the past 5 decades as new challenges emerged and novel attempts to suborn the legitimacy of recruitment processes have come to the fore. The Delhi High Court in the present case upheld the view of the Central Administrative Tribunal that the cancellation of the entire process was invalid, but it confined the relief to 6 candidates who had moved the proceedings before the tribunal in the first instance. Like other cases of its genre, this batch of appeals calls the court to balance two competing considerations: the need to preserve public confidence in and the sanctity of selection to public posts, and the requirement of observing fairness to candidates who invest time and resources in attempting to clear through a selection. Both these considerations have a constitutional foundation going beyond service and administrative law principles. The issue has traveled to the court for resolution, and the path ahead requires us to revisit and evolve the law on the subject. This batch of 12 appeals arises from a judgment of a division bench of the High Court of Delhi dated 13 January 2020. Two petitions under Article 226 of the Constitution were instituted by the Delhi Subordinate Services Selection Board in order to question the legality of the orders of the tribunal dated 1 February 2017 and 27 February 2017. The tribunal annulled the decision of the government of the National Capital Territory of Delhi to cancel the recruitment process conducted for appointments to the post of head clerk. As a consequence, the tribunal directed the board to conclude the selection process, for which the Tier I and Tier II examinations had been conducted. The proceedings before the tribunal into OAS 1 were instituted by a total of 6 applicants. The tribunal's decision entails that the benefit of its order setting aside the recruitment process would ensure not only to the 6 applicants who had moved it but to others as well, though they had not challenged the cancellation of the recruitment process. The High Court by its judgment held that the orders of the tribunal dated 1st February 2017 and 27th February 2017 setting aside the cancellation of the recruitment process were in accord with the legal position. The relief would stand confined to the 6 applicants who had moved the tribunal, and each of the 6 applicants, who were respondents before the High Court, would need to take the Tier 2 examination afresh within a stipulated period, and the appointment process would be taken to its logical conclusion for them. The batch of special leave petitions which arises from the judgment of the High Court can, for convenience of exposition, be bifurcated into 3 categories. The 6 candidates who succeeded before the tribunal and the High Court in regard to the setting aside of the decision to cancel the recruitment process are aggrieved by the direction of the High Court requiring them to appear in the Tier 2 examination afresh, and candidates who had not challenged the annulment of the recruitment process